Honorable Ssegirinya and Honorable Ssewanyana, can you hear us?
Yes, we are following the procedures, Your Worship.
Alright, we can start.
Please, Your Worship, my name is Cornelius, appearing together with my young friend, Asman Basaliwa, Honorable, and also Honorable Shannon Mende, for the accused persons. The state is represented by my young friend Richard William, and we are here to get to understand the status of the proceedings. We are ready to proceed with the matter, Your Worship.
May it please Your Worship. This matter was coming up for further mention. And probable committal of the accused person to High Court. Wish to inform you that the inquiries in this matter are complete and the committee papers are underway. They'll be ready in the next adjournment. So we seek one more adjournment. Because we are still within the lifetime of the 6 months. So that we have the accused persons committed by it. Application is in good faith. Evidence being misinterpreted. We so pray.
Before you take in, the last time the court sat, you had informed court that there was an amendment to be done.
Yes, true. There's an amendment of a gentleman called Ssegirinya, who is supposed to appear alongside the two accused persons. But he's playing hide and seek in prison. He's changing names. And that's a challenge as to why. We're even unable in the last time. He was remanded on other charges, still within these same cases of mass murders. And I have just been talking to OC Prison to ensure they get him. Because every time they reach him, he says he's not the one. So now they have issued a hunt for him, and we are partnering to ensure that the next adjournment will be produced alongside the two accused persons, the relevant members of Parliament.
Which prison is this?
They should be Chikara Prison. That's how we suspect him to have been remanded. We still pray, Your Worship.
Your Worship, we take exception of the order from the state. If anything, Your Worship, which is an affront to the due process, which is supposed to be guarded by the just like guarded by the sovereign. You could tell even from the submission of counsel for the state, and it is all over his face. Guilt is all over his face. From his submission, Your Worship, he said, this is made in good faith. Who told him it is not in good faith? That's the defense mechanism. It's a defense mechanism that it shouldn't be misinterpreted, it should be taken in good faith. You could tell already he's on a shaky ground. That said, Your Worship, we are concerned about the abuse of the freedoms and rights of our clients. They have been in jail since 7th September. That is from the record of the 2 files. I know, and I'm right with the fact that yes, court is addressing itself to.
Councillor, just a moment. Can we have order in court? I see a lot of movement.
Our colleague is joining us, Your Worship.
It's okay. Council, can proceed.
For the record, Your Worship, we are joined by our senior colleague, Council Masaka. Your Worship, I was saying it's not in dispute that the accused persons have been on remand since 7th September. And on the charge sheet before you, it's alleged that the offense was committed on the 2nd of August. And up to now, they have not been committed. Up to now. That's an egregious abuse of the latitude granted to the state under Article 23 of the Constitution, because Council for the State said, after all, we are still within the 6 months time. That shouldn't be condoned by court. Because that would presuppose that the state will always treat that as a given. That we can always take our time and deal with the matter the way they deem fit. And Your Worship, in Article 28 of the Constitution, there is a command that in determination of civil rights and obligations or any criminal charge, a person shall be entitled to fair, speedy, and public. I'm looking at fair and speedy. Fair and speedy. That's a constitutional command. And under Article 44, that right is absolute. It's abuse of the due process, and indeed the provisions of the Constitution. The state will come here and say, yes, they completed the investigation, but the committee of papers are not here. Honestly speaking, there is no justification why the accused persons have not been committed. There is no justification. Your Worship, I would like, yes, this is a matter which was decided by the Constitutional Court on matters of appeal, but there is a fundamental principle of law. There is a fundamental principle of law that is being brought out in this particular authority, which I would like to bring to the attention of court in administering justice. It is Constitutional Reference number 20 of 2005. Kano Chiza versus Uganda. This is a fundamental principle which was set by the Constitutional Court, and I believe it should be respected. The applicant should not be deprived of his or her freedom unreasonably. And, well, it was about bail, shouldn't be refused merely as a punishment. Now, in this particular case, the principle I wanted to bring out to Worship is that the accused persons have been deprived of their freedom unreasonably. They have been deprived of their freedom unreasonably. And the remand is being treated as a punishment. That is unconstitutional, to treat remand as a punishment. If you have evidence that you have gathered against the accused persons, why no committee papers have been present? Why? Your Worship is on that premise that we invite you to invoke the powers this Honorable Court has got under the Enforcement of Rights. This Enforcement of Rights Act, in matters where rights have been abused, especially fundamental rights like the right to fair hearing, to magnanimously and liberally interpret the provisions of Article 23, Sub-Article 5, no, 6C, Article 23, 6C, to mean that the remand period has been from 7th. Yes, my brother can afford to laugh it off because he's not the one before. He's not the one on remand. Because why we are arguing like this, Your Worship, it is this same court handling those two files. It is this same court, Your Worship, which is been handling, like I said, these two matters. And when you look at those issues, it is a series of the same events. Arrested, brought here, charges, fresh charges preferred, remanded again. So it is a series of transactions which are all being conducted from this honorable court. In alternative, and without prejudice to the first prayer, Your Worship, and considering the provisions of the constitutions that I have cited, together with the authority of Dr. Ssewanyana, if court is convinced that yes, the period of remand runs from 29th of September, that is when, that would mean that today being 23rd of February, rather March, just 1, 2, 3, 4 days left. Your Worship, you look into those matters and make an appropriate order to ensure that justice is done within those remaining few days. Because it would appear the state would like to use remand as punishment contrary to the decision of the Constitutional Court. And it is also apparently clear there is no amendment which is going to be made. Because Your Worship, I failed to make head and tail out of his submission. He said the person they are talking about is already on remand. He reminded himself that he's going to play hide and seek. How can a person restricted and is in the confinement of the state play hide and seek? Is in the hands of the state. It really defeats reason and logic that that gentleman or the accused person who is in the hands, in the custody of the state, that is playing hide and seek, has he stopped the council from amending the charge sheet, from putting pen to paper? Because amending the charge sheet does not require the sanctioning of the accused person. After all, that accused person, they are custody. So you can see the hide and seek actually is being played by the state in this particular matter, and the court should not allow that because it's an abuse of the due process. And finally, Your Worship, we have always put on record the fact that our clients are not doing well health-wise. They need medical attention from competent physicians outside the confines of Chigo. Ever since they were remanded for 7th of September, they have never been granted that opportunity to access services of professional physicians of their choice. All that has been all that has been done in Chico is to give them that mild treatment, simple treatment, which the prisons can afford, but not thorough examination, including the use of high tech. So we do so pray, Your Worship, and I request Your Worship with your indulgence. My colleagues may have joined us to my submissions. I do so.
Your Honor, I want to do local judges of this court allow me to submit policy.
You can proceed.
I'm going to the appearing with my land colleague. At this, I'm requesting that the land trial, that the applicants be heard because they have put their hands up. You cannot see them because they are behind you.
They want to be heard.
Counsel, I can see them, but I was going to attend to them after their lawyers had submitted.
Okay, it's like this, Your Honor. I personally visited the accused persons. One of them, I found his feet are rotting. He cannot even wear shoes. I think due to the torture he received. Your Honor, if those people are not released, it's as if court is conniving with the torturers, with the people who tortured them. And Article 22, this court of the Constitution, this court is obliged to enforce the rights of the applicants. And so that by releasing them on bail. Your Honor, there was a case in this very court some years ago, I think 1987. There was a young man called Claudio Hanga who was in Masaka prison here for 5 years in that trial. When that trial came before I go, and then there was a resident judge here. He said that he could not believe that a person could remain in remand for so long without trial. So he did not give the DPP a second chance. Actually, he discharged the accused person under Section 33 of the Judicature Act, which requires that court must stem the abuse of the court process. The DPP is abusing the court process. Your Honor, it should have been the state to be in a hurry to bring the accused persons to court so that we can know who is right and who is wrong. This court is enjoined by the Constitution not to take the side of the state in abusing the rights of the accused persons. This court is required to release the accused persons on bail. In any case, Your Honor, the case of Claudio Hanga, Your Honor, is found at page 1 of 1999 Kampala law reports. It's a very destructive case. The judge was very, very annoyed about the abuse of the rights of the accused person. And he said under Section 33, court is enjoined to stop the abuse of the court process. And in that case, he just discharged the accused person without trial. In this case, these people have been on remand for a long time. They are being brought under a multiplicity of charges, yet under Section 85 of the Magistrates Courts Act. Section 85 of the Magistrates Courts Act requires that the second charge should have been part and parcel of the first charge, for which they already were granted bail. When you look at the particulars of the second charge sheet and you compare them with the particulars of the first charge sheet, you really see that it should have been maybe two counts of the same charge, for which they are not on bail. So, Your Honor, the court is actually abusing the rights of the accused persons by bringing a multiplicity of proceedings against them. And that is not allowed under Section 33 of the Judicature Act, multiplicity of proceedings. On that account, Your Honor, the accused persons should be released on bail because they are not actually on bail. They are not on bail. Your Honor, there was also one case decided by Justice Sekoko in Imari. The case of Namono versus Uganda. In that case, which is 1992 Kampala law reports, the judge said once a person is awarded bail, you cannot cancel the bail unless that very person has gone against the terms and conditions awarded under the bail. Now the accused persons never never violated the conditions of the first bail, so now they are being punished by being brought on the second charge. Your Honor, this case is directly in consonance with what happened to the case of those people basically had been tried with people who were released on bail and then they were arrested to be taken to the court martial. The East African Court of Justice in the case of Katabazi versus Attorney General, clearly the court said that in administrative proceedings which are meant to violate a court's decision amounts to a violation of the Constitution, Article 28 of our Constitution, the independence of the Constitution. Court had already acted in the first charge in this case. By bringing the second charge, it was really, they were intending to take away the independence of this court. Your Honor, stand on your feet, the Constitution and God are on your side, and have these people released on bail, because the state is abusing, the law is abusing the Constitution. Your Honor, if you don't release these people on bail, sir, it will appear as if you are on the side of the state, which is just trying to continue torturing and making these people suffer.
Yes. In addition, Your Worship, the prosecutor today has made the same prayers that are on this court record on the 22nd of February 2022. Your Worship, if you check the court record properly on that date, they are the same prayers that the state told court that the committal papers on the way. I have finished everything and I'm committing them on 10th March. So Your Worship, by virtue of that, even when he came on 10th March 2022, he clearly told this court that the reason the committal papers were not here, that he intended to make some amendments to the charge sheet, which charge sheet would be presented today. And Your Worship, that was the basis of adjourning this case to date. Your Worship, today, as we have all witnessed, the state is coming up with another excuse that the person they want to add on the charge sheet is doing hide and seek, Your Worship. So he's keeping on changing the goalposts, Your Worship. So we don't know whether actually it is the resident state attorney who is lying to court or seek, or it is actually the so-called Senyonga that he has mentioned. Secondly, Your Worship, it is also important that the state should put it categorically clear and state the exact names of the person that they are saying that they wanted to add on the charge sheet, because he has only given this court one name. And Your Worship, as a defense counsel, one of the defense counsel in this matter, I have had some interaction, and I know that there are some prisoners. Actually, I know some prisoners who confided in me that they are forcing them to write statements against
the 2 honorable members of parliament in these charges. I will not mention their names here, but I have interacted with some. And actually they are not at Chitalia, they are in Luzina prison. And it is absurd, Your Worship, that the state, in a way, it's appearing as if they are trying to look for evidence to pin the representatives of the people. And finally, Your Worship, as the Landlord Mayor and my fellow colleagues have submitted, the 2 accused persons have been in detention since 7th. Okay, they were jailed since 7th of September 2021. But all this time, they have been there without proper medication, without representing the people who voted them into office. And that is the people of Kawempe North being represented by Honorable Ssegirinya Ssewanyana, and the people of Machinge West being represented by Honorable Ssewanyana. Since they are being jailed, they have never represented them, and that is not doing the country any good. And also, Your Worship, it is also at the detriment of the projects they have started. And just to be exact, Your Worship, just on 18th of March, one Davis Mayinja passed away. And we just buried him, Your Worship. And that Davis Mayinja was being treated at Kawempe North Hospital, which is one of the projects started by the Honorable Ssegirinya. But it was basically due to the ill facilitation of the hospital because of the absence of the Honorable Ssegirinya. And also the youth that Honorable Ssewanyana had recruited into the sports activities, and himself being the major funder of those activities and groups, the youths have now become redundant, Your Worship. So that should all be taken into account. Your Worship, as we all know, Honorable Ssegirinya and Honorable Ssewanyana are members of Parliament, and currently we know that the country is in a mourning mode after having lost the Right Honorable Jacob Olanya, the Speaker of Parliament, and also the different political affiliations are in preparations for the rest of speakership. Your Worship, in that race, the Honorable Asumani Basari were here, and myself, Shami Malende, we are running for the position of speakership. But, Your Worship, the 2 honorable members have also instructed us, because Honorable Ssewanyana is desirous of also running for the position of speakership, so that we can all be vetted by the caucus. And the Honorable Ssegirinya Muhammad is also intending to run for the position of deputy speakership. So, Your Worship, and their major request is to put it on court record that they would want the exercise of voting to be halted until they are out. So it will do a lot of good if, Your Worship, the prayers of the Honorable Lord Mayor be put into consideration and they are discharged, so that they can go and participate. Because we also want to see a competitive race where myself, the Honorable Asumani Basari and Honorable Ssewanyana are being vetted by our sake to represent our country, to be the next generation speakers of this parliament. With all the submissions, Your Worship, I pray that the state submissions be treated with the redundancy they deserve, and the accused persons be discharged in line with the provisions of the Constitution as already enumerated by the Honorable Lord Mayor and Honorable Raka Fozi. I so pray, Your Worship.
just to wrap it up in the military worship. The issue of the ongoing elections has been raised by my dear sister here, my friend. But I would like to say, even if they were not to stand as candidates, even if they have no intentions of participating in the elections, they have a right to vote. And the right is not for themselves as individuals, for the people they represent. So the people of Kawempe North, the people of Machinje West have got to have a say on who should be the next speaker of this country through their representatives. And to deprive the members of parliament of the right to participate in this exercise is to deny the people of Kawempe North, is to deny the people of Machinje West the right to have a say on that very important matter of who should be the member, or rather who should be the speaker of parliament. And as of now, they are not convicts. They are suspects. And they are presumed to be innocent until proved otherwise. Your worship, there is no law whatsoever, whether granted bail or not, that bar them from participating in that election. So I invite all to look into that matter, put it into consideration, and ensure that they participate in that very important matter of great national importance, rather. They are electing a speaker who is going to take charge of parliament for the next 5 years, or 4 years, rather. So that's how important it is. And juxtapose that matter with the flimsy reasons advanced by the state to deny them their right. So we so pray, your worship, and we thank you for your kind attention and indulgence. Thank you, your worship.
Let me hear from the case persons. Honorable Ssegirinya, please address it.
Mwebale nnyo Oweekitiibwa Omulamuzi, ebigenda maaso mu kkooti byonna tubiwulidde. Oweekitiibwa Omulamuzi, amateeka agaddukanya Paalamenti eya Uganda gakkiriza buli mubaka yenna okusobola okwesimba ku kifo ky'okuddukanya Paalamenti y'eggwanga na sipiika. Era mu nsonga eno yennyini Oweekitiibwa Omulamuzi, njagala kuyita wano ku mwatwa guno bwe tuliko olwaleero, eky'omukisa omulungi ne balwera baffe we bali awo okulagira oba okuwa ebiragiro eri looya wange, balwera baffe abo abakulembeddwa Elias Lukwago, okuteekayo okusaba kwaffe okwesimba wa sipiika adanze ng'omubaka wa Machinje West. Kubanga ekifo ekyo kikkirizibwako buli mubaka. Bwe kiba nga kirungi n'ensonga baziwadde era ng'omulamuzi ozirabye nga zeetaagisa okuteebwa tugende twesimbewo n'okulonda n'okujjanjabwa, ekyo kijja kuba kirungi. Naye bw'obanga osazeewo mu ngeri endala, nsaba abalwera bange akozesa akakisa kano bateekeyo application nga basaba injunction eya kooti okuyimiriza process ey'okulonda ekifo ky'okudduza sipiika, kubanga kiyingirira eddembe lyange ery'obuntu ng'omubaka owa Machinje West olw'abantu bange benkiikirira wamu nange. Ate nga tukyali balwadde nga babeera baffe bakutegeezeza Oweekitiibwa Omulamuzi nga n'ebbanga ddene otunuulira bye tumaze wano nga bagamba banoonyereza ate nga twakugamba nti ebintu bino bibanoonyerezaako tetwabiriimu yayo nsonga olaba state akuba ekoona kumpi bwe tujja wano mu kooti webale nnyo okumpuliriza. Oweekitiibwa omulamuzi amannya nze Ssegirinya ye muke wa Kawempe North. Oweekitiibwa omulamuzi ekituufu kiri nti tuli balwadde mbeera gye tuli mu sinungi basembeyo okupima blood pressure yange ng'eri 190/120 hertz ng'eri 115 which is abnormal. Olwekyo oweekitiibwa omulamuzi olaba omanyi embeera gye ndi mu sinungi n'omuganda ngaala nti tuli balwadde wano bagezezzaako naye olaba omanyi amaliro ga gavumenti era tebasobola kukola kye balina kukola. Nina ekibumba kirwadde maze ebbanga lino bankwata oweekitiibwa omulamuzi kati kijjanjabwa nalwala kikumba. Oweekitiibwa omulamuzi ekiro manyi n'obutassa bulungi naye era nga tewali ayamba oweekitiibwa omulamuzi kijja kuba kibi nnyo oweekitiibwa omulamuzi seramuganda agaala okufiira mu kkomera naye ng'ate kooti eno kati bwe tuli mu budde buno era obuyinza obututa kubanga ennaku njeezibwayo oyinza kugamba nti omwana yagwera okuzaala mu myaka 3 yakobe namuzaala ng'okaddiye okosekose. Oweekitiibwa omulamuzi ensonga lwaki olengeranga state bwe tujja wala akubabuula. Oweekitiibwa omulamuzi ekintu ky'otaalimu ate olyokubiza abaana akujjawa. Olwekyo state yeewokomye simanya omwami oyo gwaleese erinnya mbu yeebuzaabuza tetulimu mu pulizoni wano era tetusobola okujja wano netulabika oli ali mu pulizoni bagamba batya nti agaanye olwekyo taliiyo era state erinnya liyiiza ng'alyawo. Ekyo oweekitiibwa omulamuzi tusaba tweyimirirwe. Ekyokubiri oweekitiibwa omulamuzi nga bw'omanyi enzija za paliamenti zikkiriza buli muntu okuvuganya. Ssegirinya neekiringa okuba deputy speaker wa paliamenti era obusobozi bulina because qualification esooka olina kubeera member of paliamenti. Tetulikomba convict tetukkirizibwa kuvuganya era nange nenda kali ku muganda wange ekolayo Ssegirinya Ssewanyana nti singa tufuna chance oweekitiibwa tulina kweyongera gikuyemwe tetusentakula chance yegaba mu kalulu kakuvuganya akagenda mu maaso. Tusaba tulagira baloya baffe bayimirize okulonda n'okugenda mu maaso paka nga tuyibuddwa. Ekyokubiri oweekitiibwa omulamuzi era kyensaba tusaba baloya baffe kintu kiro court order eteekebweko bagirwane bagifune bagitwale ku paliamenti ng'eyigiriza constitution ey'okulonda kubanga okulonda okwo tekuba kwa mazima nabeekanya nga waliwo ababaka babiri balamba bali mu prison naye nga ekirawo baati bawali musango yadde naye nga state ye kati kino akikozesa nga escape route bibudde okubeera nga agamba nkyanoonyereza. Omuli ogwasema yakozesa ebigambo biri oweekitiibwa omulamuzi yagamba nti omuli ogwasooka kwati judgment yakozesa mail yenyini yakyabeera nti nagamba I will mail committee them then oladdako obusengeyo olubira luno n'agamba aishara kati olwala ebigambo yennyini yabituusiza oli yakozesa mail oladdako n'agamba shara kati era simanyi kyasi yagenda kukozesa because buli budde abeera akuzaabuzabuza tusaba oweekitiibwa omulamuzi obuyinza obuyina maama waffe abantu baffe batandise okubonaabona naaba wange anzaala ali awo yalwala ekibumba era ali awo mu kooti awo nze mujjanjaba atwafiiriza omuganda tumayija debisize mbadde mujjanjaba naaba wange muwadde oweekitiibwa omulamuzi wesifuna baana nekufuma ne maama wange ali awo naye agenda kunfaako nange kennyini ndi mulwadde kubanga obulwadde bw'ekibumba noza family disease we maama bwalina were wasana obira state ng'akulira maama wange anzaala ali awo amazima g'akatonda n'amazima gagalakumputamu ulagamba maama simuwadde ekibuga kyanyiza nnyo oweekitiibwa omulamuzi maama akusaba okuddala eddaloozi eggwalirawo. Olwekyo kyennaku nnyo otero olanga gatuwadde bwekazi olwaliro ekifuluma okuba nga tukwekojjanjabo atukwekana constitution oba sipiika twetetuta sipiika okulaba nga ebitundu byaffe bera represented mu process egenda mu maaso kuba process eyo egenda ogenda mu maaso eyokonda yemukuusaba lwaki Ssegirinya Ssewanyana alondebwa nange lwaki nalondebwa representinga abantu baffe. Oweekitiibwa omulamuzi twasanyuka ng'okkiriza tweyimirire kubanga ne bashuritiizi baffe olwedde mu kooti awo bwe bali balina buli kimu ekyetaagisa okubeera nga tweyimirirwa olunaku olwaleero. Lwebalina oweekitiibwa omulamuzi.
Your Worship, I seem to have a lot to respond to because a lot has been said by my senior brothers, Lord Mayor and Masaka, and my sister, Marende, and the accused persons. But first of all, I just need to say something that my senior colleagues failed to do. With all the humility, we lost a speaker that my senior brother was talking about, and the members of parliament. The first thing they should have done is to pray that the Almighty blessing stop in the family. Which was never. Allow me say, may his soul rest in eternal peace. Let me return to the issue, first of all, of Honorable Ssegirinya, where he says he's unhappy with me about the mother. I think Honorable Ssegirinya should get the context under which I submitted in court. I remember it must have been either 22nd of February, where you said that with all due respect, your mother was in ICU. But we were here in court, but the mother was protesting at Parliament. But he had initially addressed court and said the mother is in ICU. I felt it wasn't good for a member of Parliament to say that. And I thought I should be on record in the next year that really the mother was not in ICU as had been presented by the Honourable Member of Parliament. That is the way I presented it. Yes, that was it. So I wondered how a person who was in ICU was able to run to Parliament and protest. But that said, let me reply to other issues raised by my senior colleagues. Madam Ssegirinya, the Lord Mayor said, talked of the good fight, read this application in good fight, and there is no defense whatsoever when I made my application. It is true, the accused persons have been on remand since 7th of September 2021. But that was in a different matter. That remand was in respect to Masaka CRB 606 of 2021. This is a completely different CRB. This is Uganda CRB 203 of 2021. And you are remanded on the 29th of September 2021. So really the two are not connected. So it is not, therefore, rational to attribute the remand of Masaka CRB 605 2021 to Uganda CRB 203 of 2021. So these are two completely different matters. Therefore, their remand remains 29th of September 2021. I just want to wrap this together with what my senior colleague. First of all, I'm happy that Councillor Kafuz is back to fit. I was one of the people who were actually worried when I got the news of his sickness. I am happy, Councillor, that you're back because you have added a lot on our legal table. But I just want to say that yes, you talk of duplicity and maybe the outages are likely to be defective, and you, in your observation, you saw some kind of similarity between the two. But the first charge, that is the Masaka CRB 605 of 2021, those matters originated from Masaka district. And the current case where the honourable members of parliament are appearing in court today are under Uganda CRB 203. So clearly those are two different cases, and they shouldn't be joined together on the same charge. So they can't say that and different days of commission of offence. So they are completely different. That said, the Lord Mayor insisted that accused persons needed fair and speedy trial. That is very true. they need a fair and speedy trial. However, Madam Senior Police should be mindful that this is a constitutional provision of the 6 months. And for as long as you are within the 6 months, it will be unfair to say that prosecution is stampeding the rights of the accused person. I would have probably agreed with the Lord Mayor because I respect him. If, for example, the accused persons had been or had clocked mandatorily and were actually stampeding the arrest file, there we would agree. And Lord Mayor should appreciate that as prosecution, we are all doing that it takes to ensure a fair and speedy trial in this matter. Much as we are not able to commit them in the earlier days of the 6 months, but we are within, and I'm pledging that this is going to happen. He actually gave court a copy of the ruling in the case of constitutional reference number 20/205, but I pray that court treats it with redundancy because it was referring to a matter where court, first of all, had jurisdiction and discretion. Court has no discretion in a matter like this one. There is no discretion because the accused persons have not clocked the mandatory. The discretion cannot work. Our submission would have been different if they had clocked the 6 months. That is where the discretion actually comes in. The matter he did was a matter of bail. And it is not true that prosecution is treating the remand of the accused persons as a matter of punishment. I think it's not true. It is not true. Maybe maybe if it is a political statement, that can be true. If it is a political statement, that would be a perception. But this is a legal. If it is a legal statement, then it is not true. Maybe my senior colleague was speaking politically, which prosecution is not part of.
I take exception of that, Your Worship. I'm here in the capacity of counsel and submit of matters of law. And I say that this particular authority which talks about one not to be subjected to that kind of treatment as a punishment. So to insinuate that I'm here to make a medical statement is believed on it, and I think it's an insult, Your Worship. I'm sorry to interfere with this submission.
Okay, maybe my argument was, Lord Mayor, get me well. I did not say you're here in a political suit. I know you're here in a legal suit. And my argument was, if it is true that you're here on a legal suit, then you should appreciate that the 6 months have not elapsed. And if the 6 months have not elapsed, then it would be unfair to say that prosecution is taking the remand as a punishment. It would have been different. Probably I would have agreed with you if the accused persons had clocked mandatory. That would have been a better statement. And the reason why I say political statement is maybe with politics there is no accuracy. You can't say anything. But if it is a legal statement, then it is not true that we are treating the accused persons in the remand as a punishment. We don't do this kind of stuff. Maybe Lord Mayor asked this court to interpret Article 23, 6C, in conjunction with the Enforcement of Human Rights Act. I am mindful of the Enforcement of Human Rights Act 2019 and its provisions. But it is inapplicable in the circumstances. One would say the rights of the accused persons have been stampeded on only if they had blocked mandatory period, which is not the case here. And secondly, the supreme law, that is the Constitution, suffices. So there is no abuse here. The Lord Mayor, together with the accused persons, talked about the medical attention. I, with all due respect, appreciate that every person is entitled to medical treatment. I've been on record on several occasions. And I have been one of the agitators of the accused persons accessing medical treatment, which cannot be provided by the prison authorities. However, I am informed that the prison authorities have the capacity to treat the accused persons. That's what I am informed. I am not a medic. I'm not a medic that I can analyze and say they can't. That is the information I have, that they can treat. However, I wish to say that the accused persons are entitled to medical treatment as a matter of fact. I also wish to reply to what my other senior colleague Rakafu spoke about the case of Yarkanga. Yes, it is a good authority, only at the right time and the right place. Why? Right time, because this matter is not up for trial. And secondly, they have not blocked mandatory. And right place or wrong place, because this court has no jurisdiction.
Yes, tuli live court e Masaka ku court. Omulodi amaze okuyingira mu kitundu bwena bakanso medadise Asumani basalibwa bwena webali butere ennyonnyo. Omusango gwa leero ndowooza mukimanyi omubaka Ssegirinya Muhammad ayina okubeera mu kooti eno.
Ekitiibwa omulamuzi, njagala kuyita wano ku mwatwa kuno bwe tuliko olwaleero eky'omukisa omulungi ne balwera baffe we bali awo okulagira okuwa ebiragiro eri looya wange balwera baffe abo abakulembeddwa Erias Lukwago okuteekayo okusaba kwaffe okwesimba wa sipiika Kadanze Kumbaka Makindi West. Kubanga ekifo ekyo kikkirizibwako buli mubaka. Bwe kiba nga kirungi n'ensonga baziwadde era ng'omulamuzi ozirabe nga zeetaagisako okuteebwa tugende twesimbewo n'okulonda n'okujjanjabwa, ekyo kijja kuba kirungi. Naye bw'obanga osazeewo mu ngeri endala, nsaba abalwera bange akozesa akakisa kano bateekeyo application nga basaba injunction eya kooti okuyimiriza process ey'okulonda ekifo ky'okudduza sipiika kubanga kiyingirira eddembe lyange ery'obuntu ng'omubaka wa Makindye West olw'abantu bange benkiikirira wamu nange. Ate nga tukyali balwadde nga babeera baffe bakutegeezezza Oweekitiibwa Omulamuzi nga n'ebbanga ddene otunuulira bye tumaze wano nga bagamba banoonyereza ate nga twakugamba nti ebintu bino bye banoonyerezaako tetwabiriimu yayo nsonga olaba state akuba ekoona kumpi bwe tujja wano mu kkooti. Webale nnyo okumpuliriza. Oweekitiibwa Omulamuzi, amannya nze Ssegirinya ye muke wa Kawempe North. Oweekitiibwa Omulamuzi, ekituufu kiri nti tuli balwadde, mbeera gye tuli mu sinungi, basembeyo okupima blood pressure yange ng'eri 190/120, Hams ng'eri 115, which is abnormal. Olwekyo Oweekitiibwa Omulamuzi, olaba omanyi embeera gye ndi mu sinungi n'omuganda ngaala nti tuli balwadde. Wano bagezezzaako naye olaba omanyi abaliro ga gavumenti era tebasobola kukola kye balina kukola. Era ekibumba kirwadde maze ebbanga lino lwebankwata Oweekitiibwa Omulamuzi nga tekijjanjabwa nalwala kikumba. Oweekitiibwa Omulamuzi, ekiro manyi n'obutassa bulungi naye era nga tewali ayamba Oweekitiibwa Omulamuzi. Kijja kuba kibi nnyo Oweekitiibwa Omulamuzi. Sseramuganda agamba okufiira mu kkomera naye ng'ate kkooti eno kati bwe tuli mu budde buno era obuyinza obututa. Kubanga ennaku njeziwayo oyinza kugamba nti omwana yagwera okuzaala mu myaka 3 yakobe namuzaala ng'okaddiye okosekose. Oweekitiibwa Omulamuzi, ensonga lwaki olengeranga state bwe tujja wala akubabuula. Oweekitiibwa Omulamuzi, ekintu ky'otaalimu ate olyokubiza abaana akujjawa. Olwekyo state yeewokomye simanya omwana oyo gwaleese erinnya mbu yeebuzaabuza. Tetuli mu pulizoni wano era tetusobola okujja wano netulabika oli ali mu pulizoni bagamba batya nti agaanye. Olwekyo taliiyo era state erinnya liyiza ng'alyawo. Ekyo Oweekitiibwa Omulamuzi tusaba tweyimirirwe. Ekyokubiri Oweekitiibwa Omulamuzi, nga bw'omanyi enzija za Parliament zikkiriza buli muntu okuvuganya. Ssegirinya n'ekinyumira okuba deputy speaker wa Parliament era obusobozi bulina because qualification esooka olina kubeera member of Parliament. Tetuliko convict, tetukkirizibwa kuvuganya. Era nange nenda kali ku muganda wange Ssegirinya Ssewanyana nti singa tufuna chance Oweekitiibwa tulina kweyongera gikuyemwe tetusentakula chance yegaba mu kalulu ka kuvuganya akagenda mu maaso. Tusaba tulagira balooya baffe bayimirize okulonda kuno okugenda mu maaso paka nga tuyibuddwa. Ekyokubiri Oweekitiibwa Omulamuzi era kyensaba, tusaba balooya baffe kintu kiro court order eteekebweko bagirwane bagifune bagitwale ku Parliament ng'eyigiriza constitution ey'okulonda kubanga okulonda okwo tekuba kwa mazima nabeekanya nga waliwo ababaka babiri balamba bali mu prison naye nga ekirawo baali bali musango yadde naye nga state ye kati kino akikozesa nga escape route buli okubeera ng'agamba nkyanoonyereza. Omulundi ogwasema yakozesa ebigambo biri Oweekitiibwa Omulamuzi yagamba nti omulundi ogwasooka kwa Parliament yakozesa mail yenyini yakyabeera nti nagamba I will mail committee them then oladdako olusengyeyo olubira luno n'agamba aishara kati olwala ebigambo yennyini yabituusiza oli yakozesa mail oladdako n'agamba shara kati era simanyi kyasi yagenda kukozesa because buli budde abeera akuzaabuzaabuzaabuza. Tusaba Oweekitiibwa Omulamuzi obuyinza obuyina maama waffe abantu baffe batandise okubonaabona. Maama wange anzaala ali awo yalwala ekibumba era ali awo mu kkooti awo nze mujjanjaba atwafiiriza omuganda tumayija debisize mbadde mujjanjaba. Maama wange muwaffe Oweekitiibwa Omulamuzi wesifuna baana nemufuma ne maama wange ali awo naye agenda kwefaako nange kennyini ndi mulwadde kubanga obulwadde bw'ekibumba ndoza family disease we maama bwalina wasana obira state ng'akubira maama wange anzaala ali awo amazima g'akatonda n'amazima g'abakumputamu olagamba maama simuwaffe ekibuga kyanyinza nnyo Oweekitiibwa Omulamuzi maama akusobola okuddala eddalooza eggwalirawo. Olwekyo kyannaku nnyo otero olanga batubadde bwekazi olwaliro ekifuluma okuba akakweko nnyanjuko atukwekana constitution okwaba sipiika deputy speaker okubanga ebitundu byaffe era represented ku process egenda mu maaso kuba process eyo egenda ogenda mu maaso eyokulonda yemu ku nsonga lwaki Ssegirinya Ssewanyana alondebwa nange lwaki nalondebwa representinga abantu baffe. Oweekitiibwa Omulamuzi, twasanyuka ng'okkiriza tweyimirira okubanga ne basuubikizibwa already mu kkooti awo we bali balina buli kimu ekyetaagisa okubeera nga tweyimirirwa olunaku olwaleero. Lwe balina ekitiibwa omulamuzi.